Hi and welcome to SQE Success, your pathway to becoming an English solicitor. In this video, we'll look at 3 questions in relation to standard of care and negligence, which falls under tort law in FLK1. Let's dive in. Here's the first question we tackle today. A woman, the claimant, had her belly button pierced by a body artist, the respondent. The respondent followed common practice among body artists by sterilizing the equipment and his hands using a bowl of disinfected water before performing the piercing. However, a few days later, the claimant developed an infection as a result of the piercing. The claimant is now bringing a legal claim in negligence against the respondent. Which of the following statements best describes the respondent's liability? A. The respondent is liable for having failed to complete adequate sterilization. B. The respondent has acted negligently, but is not liable as the infection occurred a few days after the piercing, breaking the chain of causation. C. The respondent owed the claimant a duty of care, which has been breached, and is therefore liable. D. The respondent owed the claimant a duty of care, which has not been breached, and is therefore not liable. E. The respondent did not owe any duty of care to the claimant in view of their relationship. You can pause the video and think about it. The best answer is D. The respondent owed the claimant a duty of care, which has not been breached, and is therefore not liable. To succeed in a negligence claim, the claimant must establish that the respondent 1. Owed them a duty of care, 2. Breached that duty, and 3. Caused the damage, which must not be too remote. Here, the body artist clearly owed the claimant a duty of care, as he was undertaking a professional service. The key question is whether that duty was breached. Breach of duty is judged against the standard of a reasonable professional in the same field, not a higher or different profession. In Bolam, 1957, the court held that a professional is not negligent if their actions are in line with a responsible body of opinion within their field. Since the respondent followed common practice among body artists in sterilizing equipment and his hands using disinfected water, and there is no suggestion that this method fell below professional standards in that field, there is no breach. The fact that an infection occurred does not by itself prove negligence. Let's look at another question very similar to the first question. Same initial facts, but this time the body artist is a junior one who had only recently begun working at a body art studio. The junior artist followed the common practice among body artists by sterilizing the equipment and her hands using disinfected water before performing the piercing. A few days later, the claimant developed an infection. What standard must the junior artist meet in order to avoid being found negligent? A. The standard expected of a newly trained body artist with limited experience. B. The standard expected of a reasonable body artist, taking into account her lack of experience. C. The standard expected of a competent body artist in the same field, regardless of her level of experience. D. The standard expected of a senior or experienced body artist. E. The standard expected of a reasonably experienced body artist, regardless of her level of experience. The best answer is C. The standard expected of a competent body artist in the same field, regardless of her level of experience. In negligence, the standard of care is objective. A professional or skilled person is judged by the standard of a reasonably competent person in that role, not based on their personal experience or level of seniority. This principle was firmly established in Nettleship v. Weston, 1971, where a learner driver was held to the same standard as a reasonably competent qualified driver. Likewise, a junior body artist is expected to meet the standard of a reasonably competent body artist. The fact that the respondent is inexperienced does not lower the required standard. If she followed accepted professional practice in her field, she is unlikely to be found negligent. Bolam test. Here is the third tricky question. Same initial facts that the claimant developed a severe infection after piercing. Medical evidence revealed that she had an unusually high sensitivity to common bacteria, which made her more prone to infection than the average person. The claimant brings a negligence claim and argues that, under the thin skull rule, the respondent should be liable for the full extent of her injury, even though her reaction was unusually severe. Is the respondent liable in negligence? A. Yes, because the thin skull rule makes a respondent liable for unforeseeable injuries. B. No, because the thin skull rule does not apply in tort law. C. Yes, because the claimant's condition made the infection more serious, and the respondent must take her as he finds her. D. No, because the respondent was not negligent, so the thin skull rule does not arise. E. Yes, because the infection was a foreseeable type of harm. The best answer is D. No, because the respondent was not negligent, so the thin skull rule does not arise. The thin skull rule is a principle of tort law that applies after negligence has been established. It holds that a respondent who is liable for causing a foreseeable type of harm must take the claimant as he finds them, and is responsible for all the consequences, even if those consequences are unusually severe due to a pre-existing condition or sensitivity. The landmark case is Smith v. Leach-Brain, 1962. However, in this case, the respondent followed accepted professional practice, which satisfies the standard of care under the Bolam test. As there was no breach of duty, there is no negligence, and thus no liability. The thin skull rule cannot apply where there is no liability to begin with. This table summarizes 3 key principles in negligence law as applied to professional body artists. In the first case, the Bolam test establishes that a professional is not negligent if they act in accordance with a responsible body of opinion within their industry, meaning that following standard sterilization practices shields the respondent from liability, even if harm occurs. In the second case, Nettleship v. Weston confirms that a junior or inexperienced practitioner is held to the same objective standard as a reasonably competent professional. The fact that the artist was newly qualified does not lower the duty of care. In the third case, the thin skull rule from Smith v. Leach-Brain holds that a negligent defendant must take the claimant as they find them, but crucially, this rule only applies if negligence has already been established. Since the body artist followed accepted practice and was not negligent, the claimant's unusual sensitivity does not give rise to liability. All 3 cases reinforce the importance of proving a breach of duty before considering issues of experience, vulnerability, or severity of harm. Have you noticed how an apparently valid argument, such as the thin skull rule, may distract the fundamental step of proving a breach of duty first? That's exactly the skill the SQE tests, and mastering it is key to exam success. I published books filled with MCQs, each built with 3 variations of a legal scenario to sharpen your analysis and deepen your understanding. It is a must-read to pass SQE1. Turn your ambition into qualification. Begin your SQE journey to become an English solicitor.